cause. Dealing with the condition itself is not enough.
Dear Mr. Massa, I'm just trying to mind my own business. What's the matter? It's just another day, another black king captured. I'm about to lose my brain, stuck inside this ghetto rapture. I got a lot of smoke. If you want it, you can have it. They want a hat trick, but this is black girl magic. Ain't talking about the kind that'll make you disappear, but I'm talking about the power of the melanin within. Ain't looking for trouble, but I'ma say this one time. I put two dukes up if you try to touch mine. We still want justice for Samir and Trayvon. You say you don't see color, but racism ain't blind. They targeting little kids whose skin look just like mine. So I'm paranoid, it's a war zone outside. And I'm a black queen, so if you ask me to step out of my car, you gon' have to snatch me. Cause I ain't going no damn well. Had to spend my whole life living unfair. Ancestors got my back and they right here. You can never understand, it's a nightmare. Living in my black shoes by the black rules. You can keep your handshake, I don't dap coons. The white man will go nuts if he cash you. But you all on his side like a damn fool. Make it make sense.
We are oppressed.
Queen.
We are exploited. We are downtrodden.
Make it make
Queen.
We are
sense.
denied not only civil rights, but even human rights.
Ahmadiyah.
So the only way we're going to get some of this
Ahmadiyah.
oppression and exploitation
Queen.
away from us or aside from us is come together
Queens.
against the common enemy. Who taught you to hate the texture of your
Ahmadiyah.
hair? Who taught you to hate the color of your skin?
Ahmadiyah.
Parents, pay attention to the books, the school system, even to your little children. Lies mixed with wisdom. His skin too bright, so he was blind to the prison. My skin just right, so I collide with division. You trying to pray to God, but we tired of religion. No savior saving, we got to save our savings. We used to pay miss, how we gon' make the slave rich? But who's to blame, and tell me why you complaining? We need a team effort just to rule the nation. Like a bad relationship, missing communication. We missing moderation. They're trying to get a poison to my population. No reparations. I'm getting tired of Satan.
We are oppressed.
I'm
Queen.
getting tired of waiting.
We are downtrodden.
Queen.
We are denied not only civil rights, but even human rights.
Ahmadiyah.
So the only
All right. Hello, everyone. Thanks for tuning back in once again to the original Queen QueenAShakur show. I'm your host, Queen QueenAShakur, and this is your morning wake-up call. So as you're coming in, please feel free to go ahead and subscribe to the channel if you haven't done so already. Be sure to click that notification bell and click the word all so you're notified each time the Queen Goddess goes live. Okay, also don't forget to follow me on Instagram at Dr._A_Shakur, TikTok, Twitter or X at DGoddess27. And as per usual, if you don't like what the Queen is cooking, you already know what to do. Okay, hey, Andrea, Diddy in Dallas is here. All right, kicking it with Auntie Leah, Dervis. All right, let's get into it. Boo Nass, Pearly, Andrea. Everyone hit that like button. I see you, Jeff ATL. All right, so shout out to all of my loyal royals and everyone tuned into the Queen. Shout out to my moderators putting in work. Now, before we get started, let's have a brief word from my sponsor at 12 Tribes, because we got some paperwork to go over. Hey, Claudette. Okay, so let's get into it.
Do not buy 12 Tribes on Earth hair growth oil and hair magic elixir unless you want super healthy, gorgeous hair that grows. They have a whole line of amazing hair growth products, including hair growth leave-in conditioner spray, hair growth shampoo, hair growth spray, and hair growth butter. I'm starting to sense a theme here. They include quality natural ingredients. They smell amazing, and you can see the results for yourself. So if you're looking for healthy hair growth for your natural or relaxed hair, try 12 Tribes on Earth today.
Okay, so don't forget you can purchase 12 Tribes oil for your hair at Etsy.com. Just look for Lisa Crafts. You can also find it at Walmart.com. Okay, so let's get into it, honey, because Diddy and his team think they are so slick. They think they are so slick. So I'm about to pull up these legal docs. I told you all last night that I had more docs on Diddy, and I didn't have time to go through all of that stuff last night. Okay, so we're going to talk about it because they're trying to get evidence excluded in the hopes that it will help Diddy's case. Bless his heart. But I know what their strategy is. I know what their strategy is, and we're going to talk about it. So everybody, please hit that like button. Okay, don't forget to like and share the video. Thank you in advance. Okay, here we go. Let me put my watermark on here. All right. Now, in this motion, Mr. Sean Diddy Combs has filed to have evidence excluded. All right, defendant Sean Combs' motion to exclude Rule 413 and 404B evidence. So he's trying to get rid of some of this evidence, and you know, some of the motions and arguments that Diddy's camp has raised are very reminiscent of some of the same arguments that Harvey Weinstein's camp has raised. And you all know that Harvey Weinstein's, one of his convictions was overturned. Okay, and he's going to be heading back to trial for that. I believe it's April the 15th. Okay, in just a few days. And I think Diddy is going for something like that. Just in case if he does get convicted, they're already setting up for an appeal. And we're going to get into it. Okay, so let's go over these documents. And just remember, folks, you heard it here first. Okay? Now, with that all being said, here we go. Let's get into the introduction. So after months of refusing to disclose the identity of alleged victims and just 60 days before the trial, the government suddenly announced that it intended to shore up its case with evidence of blank uncharged and uncorroborated crimes, including blank purported instances of assault, all but one of which supposedly occurred decades ago. These incendiary allegations are substantially more serious than the charged offenses. If admitted, would make it impossible for Mr. Combs to receive a fair trial. Now, I've been telling you all for months and Sundays and even last year that they're definitely going to, they've already framed it as Diddy's not going to be able to get a fair trial. And in reality, he may not be able to because the jury pool has been so muddied, like I've told you time and time again, with all of these people coming out telling lies in the civil cases. And everybody's hearing about this case because it's so highly publicized. Okay, so surely whoever is going to be on the jury has been privy to that information. And even though the civil cases have nothing to do with the criminal cases, it's the fact that they're going to be able to show, or these people may have seen that a lot of people have lied, or that Diddy's suing for defamation, even suing an attorney. Okay. Now suing Warner Brothers for that documentary. So all of these things are prejudicial. Okay, so anyway, let's keep going. Now, they say, for example, the indictment does not allege blank. Instead, the charge focuses on allegations about domestic abuse or supposed economic coercion of longtime friends. That is the case Mr. Combs has been defending for months. Now, on the eve of the trial and after two superseding indictments, the government has surfaced a new plan to taint his trial with evidence about purported heinous acts. And then, as you can see, they have some of that redacted, including an allegation that blank. Now, there are entirely new, untested, uncorroborated, and uninvestigated allegations. All but one of the alleged incidents happened over 20 years ago, with the oldest dating to the 1990s. Some of the allegations are demonstrably false, but would nonetheless require an enormous amount of trial time to disprove. Some are truly unknown to the defense, and the government's disclosure has been utterly threadbare so far. The allegations implicate dozens of unidentified witnesses and alleged co-conspirators around the world, and some of the key witnesses to the supposed indictments are dead. Now, the defense is not even permitted to share the identities of the individuals described in the disclosure letter with Mr. Combs until April the 18th. Further hampering defense counsel's ability to investigate. So they're saying, listen, we're on the eve of the trial. The trial's right around the corner. Okay, the trial is right around the corner, and all of these things have not been cleared up. And then we won't even get to know the names and identities of these other individuals until April the 18th, giving us even less time. Collectively, these new allegations require many months, if not years, to investigate, and if admitted, would require a series of mini trials, certain to double the length of a trial that the government originally said would last 3 weeks. Now, they say the government initially told them the trial would last 3 weeks, and I do remember that being reported, but now they're saying this could double the length of it. So the court should require the government to try the case it charged and prove that case to the jury beyond a reasonable doubt. The government should not be permitted to pollute the trial with decades of dirt and invite a conviction based on propensity evidence with no proper purpose by painting Mr. Combs as a bad guy who must have committed the charged crimes. The evidence of alleged uncharged S assaults must be excluded under the federal rules of evidence for multiple reasons. The evidence is not admissible under Rule 13 or 413 because Mr. Combs is not formally charged with crimes of S assault as required by the rule. So the RICO S trafficking and Mann Act charges are not S assault. Those are not S assault crimes within the meaning of Rule 413. Now, the evidence is not admissible under Rule 404B because the only possible inferences go to Mr. Combs' character and propensity and not to any proper purpose under that rule. The notice is also patently deficient, okay, as the government fails to articulate the proffered evidence's permitted purpose and the reasoning that supports that purpose. As required by Rule 404B3B, the evidence is also inadmissible under Rule 403. Indeed, it is hard to imagine any evidence that could be more unfairly prejudicial or more likely to confuse the issue, mislead the jury, cause undue delay, and waste time. Finally, the government has failed to make the foundational showing required by Rule 104B. Now, this tactic cannot be allowed to succeed. Mr. Combs must be tried only for the charged offenses, and his guilt or innocence must be determined based on evidence that is actually relevant to those charged offenses. If the government's evidence were allowed, it would mark one of the worst abuses of power ever. One of the worst abuses of character evidence rule in the history of American law. Now, I'm going to tell you what they're doing. Please pay attention. So what they're doing by all of this is they're setting this up for an appeal, because even if the judge doesn't go for their argument here, if Diddy is convicted, they're going to have this on the record for the appeal. Okay. And here's the thing. They already have some of the things, they have already been making some of the same arguments, like I told you, as Harvey Weinstein's attorney. Okay. Now, Greta said, exclude, appeal. Nothing is going to work for Diddy. It is time for him deeds. Well, it absolutely is time, beloved. But unfortunately, the court system doesn't always work in the favor of the person, of the victims. And that's just being realistic. I mean, we can say what we want to happen, what we hope happen, but we have to be realistic because we do know in this country how the system works. So it does not describe what evidence, if any, or what forms of evidence, if there are different kinds, the government might offer to prove the alleged assaults. Nor does the notice indicate there is any evidence corroborating these blank stories. For example, the notice does not describe any investigation the government might or might not have conducted into the alleged assaults. Nor has the government produced any meaningful discovery related to the noticed acts. The scant discovery the defense has received regarding any of these indictments came long after the government's December 31st, 2024 deadline. So they're saying this all was, the deadline had already passed. Now, the government apparently and troublingly plans to rely at trial on the alleged victims' uncorroborated allegations alone. So the allegations in the notice are themselves suspect and largely track allegations drafted by plaintiff's lawyers seeking to shake down Mr. Combs in multiple other forums. Importantly, not one of the alleged assaults resulted in any criminal complaints or criminal charges. The majority of the blank purported victims, okay, then there's many redactions. There's even redactions in the footnote. Now, here's the argument. In sum, nothing in the notice or in discovery to date lends any credence to these stories, and there is no basis in the record to believe the notice evidence is at all reliable or true. Now, the argument says the proffered evidence is not admissible under Rule 413. The government offers the government proffers the evidence under Rule 413, which is a limited exception to Rule 404's general ban on character and propensity evidence. In cases alleging S assault, Rule 413 allows evidence of the defendant's prior instances of S assault to prove his propensity for violence. However, Rule 413 only applies when a defendant is charged with an S assault offense. So they did not charge Diddy specifically with an S assault offense. That is true. Now that means the indictment must formally charge the defendant with an S assault offense as defined in the rule, because the second indictment or superseding indictment, that one contains no such charge. The government's proffered evidence is not admissible under that rule. So let's talk about proffered evidence. Okay, let's talk about what exactly proffered evidence is, okay? Well, that's basically evidence that is going to be offered or presented at trial for, for it to be accepted or rejected. It's used to create an appellate record, okay? Because usually, very often, this evidence has been deemed inadmissible by the judge. The judge has excluded this evidence, but they want to present it anyway to show what it could have shown, to show what it could have proven. And they do this to have it on the record for when they file an appeal after the person, if the person is convicted. That's why I'm telling you, they're absolutely setting this up for Diddy to get an appeal. So even if Diddy is found guilty and convicted, they're of course going to appeal it. So they're already setting their ducks in a row so that they can try to win on appeal. You see, that is what happened with Harvey Weinstein. And like I said, we're going to talk about that in a minute, because Harvey Weinstein's team made some of the same arguments, and then they ended up getting one of his great convictions overturned. Okay, they won the appeal, and now he has to go back to trial. Okay, so with that all being said, now here's what they go on to say. That means the indictment must formally charge the defendant with an S assault offense as defined. Now, because the second indictment contains no such charge, the government's proffered evidence is not admissible under the rule. Now, Rule 413's text and threshold requirements. Here are the requirements of this rule. Permitted uses. Okay, A, permitted uses. In a criminal case in which a defendant is accused of an S assault, the court may admit evidence that the defendant committed any other S assault. The evidence may be considered on any matter to which it is relevant. The definition of S assault. In this rule, and Rule 415, S assault means a crime under federal law or under state law involving 1, any conduct prohibited by 18 U.S. statute. Okay, and then they just basically go on to explain the law. So I'm going to skip past all of that. Then they also have some cases that they reference. Now, the court held that Rule 413 applies only when a party has been charged with an offense of S assault in the indictment, and that a verbal accusation during the investigation into the offense was insufficient. Saying basically just because somebody said that he S assaulted them, that's not good enough. You have to actually have that in the charge and indictment, which they don't. Now, in contrast, in the United States versus Ahmed, the 8th Circuit held that a defendant does not be charged. Okay, a defendant need not be charged with an S assault offense to trigger the rule. And what matters is whether the offense he was charged with involved conduct that Rule 413 deems to be S assault. Okay, there the defendant was charged only with kidnapping, but the allegations included an S assault, which Ahmed deems sufficient to trigger the rule. The decision is currently the subject of a petition of a writ of certiorari. Okay, so that's one of the cases they reference. Now, I don't see how that referencing that helps their case, because they're saying that it did meet the rule, the expectation of the rule. And it kind of, to me, sounds similar to Diddy's. Are they saying that it isn't? So multiple commentators have emphasized that the rule's threshold requirements must be interpreted narrowly. They have rejected the 8th Circuit's approach, observing that Rule 413 would not apply in trials for kidnapping. For example, even if the evidence shows that the defendant committed an S assault during the course of the crime, nor would it apply if the defendant is charged with murdering the victim of his S assault, but is not also charged with S assault. So I guess he's saying that it didn't apply in that case, even though it could have, it didn't, because the guy was charged with kidnapping. Various district courts have similarly interpreted the rule narrowly. Okay, they go on to list more cases. Now, then says the Second Circuit has not had occasion to decide the issue. Okay, they list more cases. I'm going to skip past all of that. Now, the plain meaning of accused is sufficient to resolve the question. The rule's legislative history confirms the same point. The rule was intended to have a limited application and does not apply in the absence of a formal charge of S assault. When the rule was initially introduced, the analysis statement said Rule 413 and corresponding Rule 414, applicable in cases where someone did that to a child, only applied in prosecutions for S assault and for child molestations with an M. Now, it stated that the proffered evidence must relate to other crimes by the defendant that are the same type of S assault or child molestation. Now, as the crime with which the defendant is formally charged, okay, their application is confined to S assault and child molestation cases, and only evidence of crimes of the same type as the charged offense may be shown. So basically, it sounds like they're saying that, you know, this doesn't have anything to do with the case, with the charges against Diddy in the indictment. But how do they not? Because Diddy has been charged with S trafficking, okay, and that has something to do with S assault. Now, anyway, the principal House and Senate sponsor statements confirm the same point. Senate sponsor Robert Dole said the rules amended the federal rules of evidence to allow the introduction of evidence of prior offenses of rape and child molestation in prosecutions for these same offenses. Okay, I'm going to skip past all of this. Now, the corresponding DOJ statement supporting the new rules further observed that Rule 413 does not indiscriminately admit evidence of all the bad things the defendant may have done in the course of his life, but only admits evidence of criminal offenses of the same type as those with which he is formally charged, thus limiting the number of incidents for which evidence may be offered. Okay, now I see where they're going. Now I see where they're going, beloveds. Okay, so here's the thing. Here's the thing. So basically, they're saying that all of these people who have made allegations against Diddy, you know, with all of these civil cases and whatnot, specifically, all of these people have made allegations against Diddy. That doesn't have anything to do with this case because Diddy has not had any of those. You know, there's no children involved. People made allegations of him doing things to minors. Okay. And then, you know, these people talked about being given illegal substances and all these things or whatever. You know, basically, none of that has been implemented in the indictment, neither of the indictments. So they're saying you can't have, we don't want evidence from any of that stuff being brought into the court because it doesn't have anything to do with it. He's absolutely doing what they did in Harvey Weinstein's case. Because do you all know why Harvey Weinstein's case was overturned? I'm so glad you asked. Harvey Weinstein's case was overturned because the prosecution allowed people to testify against him who accused him in civil cases, but their cases didn't have a darn thing to do with the criminal case. That's what his team came back and said, that prohibited him from having a fair trial. Do you all get what I'm saying? Once in the chat. Once in the chat, if you all understand what I'm saying. I want to make sure you all are comprehending this because they got this whole thing set up. You all understand what I'm saying? Once in the chat. So that's basically what they're doing. They're absolutely doing the same thing. Okay, please pay attention, honey. They're following the same pattern of Harvey Weinstein's case. They're like, that doesn't have anything to do with this case. It's not even formally in the indictment. Even if someone accused him of S assault or doing something to a minor or whatever, that don't have nothing to do with this because y'all didn't put it in the indictment. It's just an allegation that you didn't even investigate to find out whether or not it's true. Okay? And then here's the thing. The civil cases are not even going to be resolved until after the criminal case. Okay, so let's keep going. Likes up, everyone. Please don't forget to like and share. Thank you in advance. Okay, so I'm going to scroll down some because this is like 30 some pages. I'm not going to read this whole thing. Skip past some of this legal mumbo jumbo. Okay, now let's talk about the indictment does not charge S assault, this section. Okay, now the second indictment does not charge a crime of S assault, as that term is defined in Rule 413, rendering the government's proffered evidence inadmissible under the rule. Rule 413 defines S assault as a crime under federal law. Okay, we already went through that. So they're saying that it renders the government's proffered evidence inadmissible. Now, here's the thing. They're saying the government has proffered evidence, right? Okay, so like I said, Diddy's team is setting up the appeal, but the proffered evidence would not come from Diddy's team, of course. That would come from the government. It's like when somebody makes a proffer agreement. Okay, when somebody makes a proffer agreement, that means the government makes a deal where they're going to get certain information from this person, but at the same time, they make the agreement that it prohibits the government from using, that evidence against them. Okay? It's like you can come and tell me what happened. And if you were involved in the illegal activity yourself, it's like the same thing with Dwayne Keefe D. Davis. That's what they gave him. They initially, when he came and brought them evidence about Tupac or about Tupac's death, he had a proffer agreement, which meant that anything he told them during the interview, any evidence he gave them, even if he admitted culpability that he was involved, well, then they couldn't use it against him. But now you see he's sitting in jail because that was only intended for the interview. But he went and talked about it elsewhere. So that's a proffer agreement where you really are not supposed to be charged with the same evidence that you used to help the prosecution's case. But proffered evidence is basically the same thing. It's like if they know that there might be an appeal, they want to have that on the record. That would be the prosecution wants to have that on the record in case the person tries to go back and get an appeal. I said it backwards. I misspoke because I initially framed it as if Diddy's team would want that deal. But no, this is the prosecution because they obviously see, of course, that Diddy's team is setting up for an appeal. Okay, so then they would have this evidence. Like I said, it's evidence brought to the trial that the court may have excluded, but they preserve it for the issue of appellate review. Okay, the proffer can be made by presenting the actual testimony or the document excluded on the record, or by simply explaining what the excluded evidence would have shown, like I initially told you. And here's an example. Okay, if an attorney believes a witness's testimony is crucial to their case, but the judge rules it inadmissible, the attorney can make a proffer to ensure the testimony is part of the record in the case of appeal. Okay, so that's what can happen. Okay, so well, then I was right. I didn't misspeak. Okay, I did because I haven't studied this stuff in a minute. The proffer situation. Okay, so basically, Diddy's attorneys can do that. They can have the evidence shown in court, even if they say, it's not going to be it's going to be excluded. You can't bring it in. They could still bring it back or have it put on the record for their appeal. Okay, so either can do that, the prosecution or the defense, apparently. But like I said, either way, they're setting up for an appeal. Okay, that's what they're doing. They're absolutely setting up for an appeal. So, and it looks like they're following the same pattern as Harvey Weinstein's case. And we're going to talk about, I'm going to show you some receipts from Harvey Weinstein's case after this, because Diddy thinks he's so smart. And now, like I said, they're fighting to keep out certain evidence and whatnot, filing all these nefarious motions. Now, if you all missed the video that I did last night, please go back and watch that one because there was more court documents. Okay, now, anyway, let's keep going. So the remaining subsection of Rule 413D refers to crimes involving specified forms of S contact without consent. deriving sexual pleasure or gratification from inflicting death, bodily injury, or physical pain on another person, and attempts and conspiracies to engage in this conduct. Now, in this context, the word involving must mean as an element of the crime, not merely as a circumstance of its commission. Okay, meaning the crime charged must require such conduct. But again, that the charges here do not require any such conduct. So they're saying, listen, if that rule is going to apply, you have to have either charged him with S assault, or whatever the indictment is charging him with has to be affiliated with that. And they're claiming that it doesn't. Now they say the RICO conspiracy and the alleged racketeering acts do not require proof of an S assault. The same is true of count 2. That statute requires knowledge that force, fraud, or coercion will be used to cause the victim to engage in a commercial S act. But it similarly does not require any consensual sexual contact between the defendant and the victim. Similarly, the Mann Act violation charged as count 3 requires an intent that the victim engage in prostitution. But that does not in turn require any non-consensual sexual contact between the defendant and the victim. For these same reasons, courts routinely find evidence inadmissible under Rule 13 or 413, where the defendant is not charged with either a Chapter 109A offense or a crime that requires an S assault as defined in the rule. Honey, they're fighting hard to keep this evidence out. Please pay attention. Now, in some, the proffered evidence does not satisfy Rule 413's requirement because Mr. Combs is not accused of an S assault. See, he's only accused of S assault in the civil cases, not in the criminal cases. Multiple allegations of S assault in his civil cases. But again, those have absolutely nothing to do with the criminal case. And if the prosecution were to try to get any of those victims or those accusers from the civil cases to testify against Diddy in the criminal trial, and they're not officially in the indictment labeled or listed as a victim, then they can do the same thing Harvey Weinstein's team did, because that's exactly how they got his case overturned. Okay, please pay attention. Now, the proffered evidence is not admissible under Rule 404B. So the government suggests in the alternative that if the evidence doesn't qualify as Rule 413 evidence, that it can be admitted under Rule 404B2 instead. That doesn't work either. Start by calling a spade a spade. Ha! No, they didn't. Are y'all hearing this? Are y'all hearing the shenanigans, honey? No, he didn't say start by calling a spade a spade. Getting slick with it. This is all a hot mess, but let's keep going. So he says, start by calling a spade a spade. What the proffered evidence tends to demonstrate is a propensity for sexual violence and a dangerous, depraved character. That is what the government wants to establish, and it is the real purpose of this evidence. But unlike Rule 413, Rule 404 does not allow the admission of evidence to prove character and propensity. The other purposes in Rule 404B2 are non-propensity purposes. There is no conceivable non-propensity purpose here, and merely repeating the words of Rule 404B2 is not sufficient. Now, the government's notice is deficient under Rule 404B. So as an initial matter, the government's notice is patently deficient. The government provides no explanation of what the supposed proper purpose is as to any of the alleged incidents other than to state that it may seek to introduce at trial evidence of the following acts in order to prove the defendant's intent, knowledge, preparation, plan, motive, modus operandi, and absence of mistake or accidents. Such a lazy laundry list of proposed purposes, quoting the rule's text, does not comply with the requirements that the government articulates in its notice, the permitted purpose for which the prosecutor tends to offer the evidence, and the reasoning that supports the purpose. The rule formerly required only a more generalized sort of notice, but the old rule was frequently abused by prosecutors who were merely provided boilerplate notice that they planned to admit a defendant's other bad acts. Such boilerplate made it impossible for district judges to assess admissibility. Thus, even before the amendment, courts around the country had ridiculed the so-called laundry list approach to determining admissibility under Rule 404B, because a mere recitation of the purposes of Rule 404B2 is insufficient and supplies the defendant with little notice of the non-propensity purpose for which the evidence against him is being admitted. And it says nothing of how the evidence is probative of that purpose. And then he lists some more cases, okay, to give examples. Consequently, to discourage that sloppy and unhelpful practice, the rule was amended in 2020 to impose more stringent requirements. Now, in general, the rule requires reasonable notice of any such evidence so that the defendant has a fair opportunity to meet it. As the advisory committee explained, such notice is important so that the parties and the court have adequate opportunity to assess the evidence. Okay, so and this is pertaining to the 2020 amendment. Now, as is discussed, the amended rule also requires the government to articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. So as the advisory committee explained, the prosecution must not only identify the evidence that it intends to offer pursuant to the rule, but also articulate a non-propensity purpose for which the evidence is offered and the basis for concluding that the evidence is relevant in light of this purpose. The government apparently didn't get the memo. Clearly throwing shots. He's basically saying, did they even bother to read the amended rule? They amended it in 2020. Do they even know that it was amended? Is basically what he's saying. Did anybody tell them that the rule has changed? Now, it still provided only the sort of very general notice that was allowed under the old rule, but not the amended rule. The notice is insufficient to allow the defense to investigate these incidents and meet the evidence as the rule requires. And the notice does not specify the non-propensity purpose or explain how the evidence proves that purpose. The government thus continues to employ a worst practices approach to the rule. Now, the government must explain exactly how the proffered evidence should work in the mind of a juror to establish the fact the government claims to be trying to prove. Only then can the court determine whether the prosecution is overtly or covertly relying on forbidden propensity reasoning. Now, the notice provisions of Rule 404 are not mere formalities, particularly where liberty is at stake. Due process demands that the individual and the government each be afforded the opportunity not only to advance their respective positions, but to correct or contradict arguments or evidence offered by the other. Now, it is obvious the government either intentionally withheld notice of the purpose of unfair surprise or for the purpose of unfair surprise, or was dilatory and negligent in its investigation. Okay, it says obviously the government either intentionally withheld notice for the purpose. Okay, so basically saying that they did this to make it like a surprise, like to, throw them for a loop, to catch them off guard. Okay, and like they're bringing this in at the last minute when they could have told them this months ago, basically. So the government knows it is impossible to investigate these allegations in 60 days. So now they're saying we don't even have time to investigate this to find out if it's any viable evidence. Okay, they're telling us too late. The clock's ticking. The trial's right around the corner. And here they come and they want to bring this in. No, we shouldn't have to deal with this. This should not be allowed in because we won't have adequate time. See, I'm telling you, they are so slick because what they're doing is if the evidence is admitted in, they're going to ask for a mistrial. They're going to say that Diddy didn't get adequate. They can even argue, Diddy could even argue that he had ineffective counsel. He could even argue that he had ineffective counsel. Okay? I mean, there's a myriad of things he could argue for an appeal if they let the evidence in. So that's exactly what they're doing. Okay, so anyway, it is obvious the government said that they either intentionally withheld notice for the purpose of unfair surprise or was dilatory and negligent in its investigation. Now, the government knows it's impossible to investigate these allegations in 60 days, especially while simultaneously preparing for trial, receiving and reviewing Jinx Act material and expert disclosures, and preparing motions in limine. Indeed, since the beginning of the case, the defense has been asking the government to identify alleged victims, precisely so that Mr. Combs could investigate and prepare his defense. He said they really are letting the clock run out and they have too much to do. And this is not adequate time, honey. They're going to go for a mistrial. I'm telling you, are definitely going to come back on an appeal. Now, if Diddy gets convicted. Now, indeed, since the beginning of the case, the defense has been asking the government to identify alleged victims. Okay? Precisely so that Mr. Combs can investigate and prepare his defense. The government did not identify any of the individuals in its notice until 10:31 p.m. on March 17th of 2025, after the court ordered such disclosure. So basically saying the court had to force them. They still weren't going to give it to us anytime soon until the court forced them. And it was 10:30 at night. Okay, just a few weeks ago. This court has authority to exclude the evidence solely based on deficient notice. Okay, and then they give an example of a case where they had evidence where government failed to provide sufficient advance disclosure and defendants cannot adequately prepare to refute the evidence with approximately 1 month remaining before the trial. So they already have a case where the judge ruled the same thing that they're asking for. It should do so here based on the government's failure to comply with the amended rules notice requirement and the impossibility of preparing to meet so many additional allegations at such a late date. Now, the relevance of the proffered evidence depends on impermissible propensity inferences. Okay, notice aside, what the government's laundry list approach reveals is that it cannot articulate a non-propensity inference because there is none. These acts do not demonstrate anything other than propensity, and simply reciting the words in Rule 404b2, that changes nothing. The acts are mere propensity evidence in sheep's clothing. Ha! Oh my goodness, these people are something else, okay? Now, on their face, the proffered purposes do not even make sense. For example, the government suggests that all the prior acts show planning and preparation for the charged offenses. How does blank show the defendant was planning and preparing to commit a S trafficking or man violation? So basically saying, how can y'all prove that he was planning something like that? That doesn't even make sense, as the proffered acts are not sufficiently similar to the conduct at issue to permit a reasonable inference of knowledge, intent, or plan. And then the People versus Weinstein. Do y'all see that? And that's not the first time they've mentioned Weinstein in one of their arguments. And they also mentioned Epstein in the argument too. And I want y'all to pay attention because I'm here to tell you this is exactly their game plan. They're like, oh, we're going to get him off one way or another because even if he gets convicted, we're going to come right back around because we're already setting the stage. Okay? They're going to try to pull a Weinstein and have I'm telling you, that's what they're going to try to do. They're going to try to have a retrial, if anything. Now, or they're going to definitely, they've already been setting the stage, as I told you, to say he's not able to get a fair trial. And now they're just adding more stuff to the pile so that they'll have more evidence when they go for an appeal. But anyway, goes on to say, okay, so they reference the Weinstein case. And then they go on to say, describing significant differences between complainants and the Molyneux witnesses, including that all three complainants had long-term relationships with the defendant, whereas the Molyneux witnesses were interacted with defendant for brief periods. Now, the government may argue that the prior alleged acts of violence against women show Mr. Combs's intent to commit the charged acts, which involve violence against women. But the jury could reach the conclusion of guilt based on the prior acts, only if it first concluded that he had a propensity of violence against his girlfriends and partners. That is not permissible. 404B2, reasoning to intent. It is impermissible propensity reasoning. And there again, they say, see Weinstein. So again, they refer to the Weinstein case. Now, in other words, it is not enough to simply state that the evidence is offered to show intent or any of the other listed purposes. What is required is demonstrating that the evidence proves intent without relying on propensity as a necessary link in the inferential chain. But simply, it doesn't matter what label is attached. What matters is the chain of inferences. No matter how it's labeled, if the use of the other act evidence would require an inference that the other act showed the defendant's propensity to perform acts of that type, and further inference from that propensity that the defendant therefore performed the act charged, then evidence is barred by Rule 404. And then they list another case as an example. This is Hornbook law. To be admissible under Rule 404B2, the evidence must have special relevance to an issue in the case, such as intent or knowledge, and must not include bad character or propensity as a necessary link in the inferential chain. When evidence of the prior bad acts is offered, let me tell y'all something. Oh my goodness. I want you all, are you all paying attention? Are you all paying attention? Because guess what? He's using now, they're even using the same language in Harvey Weinstein's paperwork and his legal papers. They're even using the same language. Nicole says they're trying to release Weinstein early from this case too. Right, he goes up for retrial April the 15th. I think it's April the 15th, in just a few days. Yeah, exactly, beloved. Now, with that all being said, yeah, they are slick. Okay, but let me continue. Now they say, hold on, where was I? Okay, when evidence of prior bad acts is offered, see, remember that term, evidence of prior bad acts. That's exactly what got Harvey Weinstein a retrial. That phrase right there, evidence of prior bad acts. Okay, I told you. Now, the proponents must clearly articulate how that evidence fits into a chain of logical inferences, no link of which may be the inference that the defendant has a propensity to commit the crime charged. Now, the proper approach is not to simply find a pigeonhole in which the proof might fit, but to determine whether the evidence proves something other than propensity. The proponent must clearly articulate how that evidence fits into a chain of logical inferences, no link of which may be the inference that the defendant has the propensity to commit the crime charged. Now, stated differently, such proof offered is not saved from the principle of exclusion by the mere fact that it supports a specific inference to a point like intent, if the necessary logical steps include an inference of general character or propensity, or if it seems likely that the proof will be used to support such an inference. The government may say that the evidence is offered to prove intent or motive or whatever, but this court must look beneath those words to see if propensity is what gives the evidence its persuasive force. Admissibility under Rule 404B is not determined by attaching simple labels to evidence, nor is it determined by repeating its conclusory fashion, the laundry list of permissible purposes in the rule. Rather, it is determined by examining the chain of inferences that make the evidence relevant. There is no permissible chain here. Quite simply, the government chain of inferences is indubitably forged with an impermissible propensity link. Basically saying this evidence that they're trying to get in is irrelevant and has really nothing to do with the case. Now, even if the evidence fits Rule 413 or 404b2, which it doesn't, Rule 404 would still require its exclusion, as the Second Circuit held, where in a particular instance, the admission of evidence prior S acts would create undue prejudice and threaten due process. District courts can and should, by operation of Rule 404 or 403, exclude that evidence and ensure the defendant's right to a fair trial. There they go mentioning that again. This is precisely such a case. This court can and should exclude the government's extraordinarily inflammatory evidence to ensure Mr. Combs' right to a fair trial. Likes up, everyone. Please don't forget to like and share. Thank you in advance. Now, if the evidence is powerful, it is powerful for all the wrong reasons. The legitimate probative value of the evidence is exceedingly low for multiple reasons. For number one, there is little reason to believe the alleged S assaults ever occurred. Okay, so basically saying these are just allegations. You don't even have proof whether or not it happened or not. And this stuff doesn't have anything to do with the criminal case. The purported evidence supporting the alleged past acts is incredibly weak, which substantially lowers the probative value. Where a past act cannot be shown with reasonable certainty, okay, its probative value is reduced, justifying exclusion under Rule 403. Now, in general, alleged prior acts that did not result in a conviction should be more cautiously admitted than those that did. The evidentiary foundation of the alleged prior acts or incidents is based, and then they redacted some of that. And as discussed in more detail below, there are ample reasons to doubt the veracity of these complaints. Some are so lacking in evidentiary foundation that they have not even resulted in civil claims or even demands. That underscores their minimal probative value. Indeed, the government has provided virtually no discovery in relation to the alleged S assaults, and certainly none that provides any corroboration that Mr. Combs committed an S assault. Okay, so here's the thing. Nor has it attempted to investigate these allegations, purportedly out of fear that they will be resoundingly disproven through their investigation. It apparently will rely at trial on the alleged victims' uncorroborated allegations alone. So basically, he's saying that, listen, you don't know if these people are telling the truth. They've not had any evidence that they can prove that these people were telling the truth, and there's already a significant reason to believe that these allegations are absolutely not true. So if this information is introduced at the trial, this is just going to be prejudicial. You don't have any way to prove it, and all you're going to be doing is putting this out there, and it's going to make the jury prejudiced against Diddy because they're going to be looking at him like, oh, so he did this in the past. And they're going to, they may be fixated on the fact that this is what he's done previously. So if he did this type of stuff, then clearly he probably did this too. But they're arguing that there's no proof that he did any of those things. That's just something that people have accused him of. And you have no proof, and you didn't investigate it, and we don't have time to investigate it. And that the reason you don't want to investigate it, prosecution, is because you just might find out in your investigation that it didn't even happen. And then further making it look like the evidence is not credible by saying that, listen, there's not even any civil cases or demand letters sent in regards to these allegations. Basically saying, so it's worthless. Okay, are y'all listening? This is all crazy. This is all crazy. And listen, when you think about cases of people like Adria English, okay, her case, because she filed a lawsuit, remember, and it didn't hold water, and then her attorney backed out of the case. If they're talking about some evidence like that, well, they have a point. And that's why I told you, all these people were going around lying just to be lying, that stuff was going to make it bad for the real people that have had things done to them, supposedly. So anyway, goes on to say, moreover, Congress recognized that the probative value of a claim of prior S assault is particularly low, whereas here there is reason to believe that the formal charge and the accusation of an uncharged offense were not generated independently of each other. That is precisely the case with respect to these allegations. None of the S assault claims in the government's notice. The claims are, to put it lightly, at the weakest end of the spectrum. Basically saying these claims don't hold water. The alleged S assaults are not similar to the crimes charged. The lack of similarity also reduces the probative value. The theory of Rule 413, admissibility, is predicted, or a similarity or similarity is thus a critical factor in weighing admissibility. And then they mentioned this other case, Schaefer. In Schaefer, for example, the Second Circuit agreed that the probative value of the uncharged acts was particularly probative due to the similarities between the prior conduct and the charged conduct. It showed a distinctive pattern of behavior. For evidence proffered under Rule 413, where the past act is not substantially similar to the act for which the defendant is being tried, the propensity inference provided by the past act is weaker, and no presumption in favor of admissibility is warranted. Indeed, the Justice Department's own policy brief advocating for the enactment of Rule 413 noted that similarity is required under the rules. So the charges, and in the indictment and the allegations have to be similar. Now, in addition, the requirement of similarity in kind to the charged offense tends to ensure that the uncharged acts will have a high degree of probative value and will not be mere distractions from the main issue. So that's what he said. This is nothing but a distraction, okay, from the main issue of the case. Noting that in a case involving charges of child molestation with an M, district court properly excluded testimony from alleged adult victims due to dissimilarity from the charges. Do you all get what they're saying? They're giving an example of a case where there was alleged, the person was charged with child molestation with an M, but then the court wanted to bring in testimony from adults who said that the defendant did the same thing to them or did something sexual to them, but it was excluded because there was no similarities, because these are children and these are adults. But to me, if it's something sexual that was done to the adults and the kids, that does seem similar to me. But hey, what do I know? I didn't make the laws. I'm just telling you about it. So here, similarity is distinctly lacking. The formal charges in this case are based on allegations that blank, blank, and blank. By contrast, the other acts proffered by the government are a mishmash of other purported sexual behavior. While the charges involve blank, the stories play are fictional. The stories play on fictional narratives spread by the media that have nothing to do with the indictment's allegations. These distinctions lessen the probative value, particularly considering the nature of the relationship between the victims and the defendant in the two settings which courts must consider. Here, unlike in Schaefer, for example, the nature of the relationship between the defendant and the alleged victim is not at all the same for the actual charges as it is for the other acts. These differences reduce probative value and militate in favor of exclusion. Now, the alleged S assaults are remote in time. So while the text of Rules 413 and 404 have no particular time limit on the acts, the date of the prior offense remains a factor for a court to consider in conducting Rule 404. Okay, I think I'm gonna stop right here. I'm gonna go to the end. And a lot of this is redacted, as you can see. I'm just going to go to the end because I can see, as we can see, we get the gist of it. They're trying to deem this evidence inadmissible, and they want it excluded. They want it excluded. So let's go to the conclusion. For the foregoing reasons, hold on. Let me back up just a little bit and read this last page. They say, indeed, courts around the country have recognized that a hearing is particularly necessary in cases like this, where the prosecution seeks to admit highly prejudicial acts under Rule 413 and 404B. Okay, and then they list a myriad of cases. An evidentiary hearing is preferred. Such hearings are necessary both to determine whether the conditional relevance standard is met and also whether the alleged prior acts count as S assaults or the prior alleged acts count as S assaults. Now, noting district court conducted a pretrial evidentiary hearing where claimed victims testified before the ruling on the admissibility of the prior acts evidence. Thus, while the evidence can and should be excluded without any pretrial hearing, it should not be admitted without a hearing. So he's saying, listen, okay, the evidence shouldn't even be allowed in because clearly it's in violation of Rule 413 and 404. But at the end of the day, if you are going to allow it to be used as evidence, then we at least need to have an evidentiary hearing so we can discuss this and go over all of the aspects of it. In conclusion, for the foregoing reasons, the government's proffered Rule 413 and 404B evidence should be excluded. In the alternative, the court should hold a preliminary hearing pursuant to Rule 104. So either exclude the evidence or at the very least, let's have an evidentiary hearing. And this is Alexandra A.E. Shapiro, Mark Agnifilo, Anna Estavio. All right. So what do you all think about all of this? Is my chat frozen? Looks like my chat's frozen. Hold on. All right. So, what do you all have to say? What do y'all think about it all? I find it all so interesting. Diddy's like, y'all getting me up out of here. Diddy's trying everything he can, honey. He's throwing stuff at the wall to see what sticks. Diddy, you're not getting out of that jail. Okay. Even if Diddy, for whatever reason, isn't convicted, Diddy, you're not getting out of there. He better be watching his back because I think they might try to pull an Epstein on him. Okay, I wouldn't be surprised. Okay, the Inkwell said money talks, BS walks. Yeah, you got that right, beloved. And so anyway, but now let's talk about this. Let's talk about this Harvey Weinstein case because like I said, much of the stuff in their playbook has come from that. Okay, so let's talk about it. Now, I want y'all to listen close. I want y'all to listen close because here's the thing. Now, the New York Court of Appeals overturned the S crimes conviction against Harvey Weinstein, the powerful Hollywood producer whose downfall stood as a symbol of the #MeToo movement, and ordered a new trial. What Diddy's planning to do, if it doesn't go his way, that's what he's already prepping for. Now, the court, by a 4-3 vote, ruled the testimony of prior bad acts. Do y'all hear that? Do y'all hear that? I told y'all to pay attention to that phrase because that's exactly what they used in Harvey Weinstein's legal documents, okay, when they were arguing. Please pay attention. Now, they say they voted by a rule, the court voted by 4-3, ruled that the testimony of prior bad acts witnesses should not have been allowed because it was unnecessary to establish defendant's intent and served only to establish defendant's propensity to commit the crimes charged. Isn't that what I just read to y'all? Do y'all hear that? Did I break it down for y'all? Well, now I want y'all to pay attention, honey, because my analytical skills are on point. Y'all see how I pieced that together? I knew exactly where Diddy was going with it because he think he's slick. Him and his team think they are so slick. Okay, do y'all see that? They're using the same language, okay? And here's the thing. Now, as I said, the very argument that they're making is what Weinstein's people made, and they won that argument because they got him an appeal, and now he's headed to retrial, okay? And things can often change during a retrial. So please pay attention. So that's exactly what they're setting up. And the reason they're making this huge argument about it is so that if the evidence is not excluded and the witnesses are in fact allowed to come in and talk about allegations of Diddy assaulting them, or evidence is brought in saying that he assaulted people who have nothing to do with the trial, who are not victims in this trial, that's what they're going to say. They're going to say, look, you brought in prior bad acts. And then they're going to refer to Harvey Weinstein's case, and they're going to get them a mistrial too, I guarantee you. And here's the thing. They're making this huge argument about it to show if Diddy does get convicted, so they can show and say, look, we tried to stop you. We tried to stop you. We warned you that prior bad acts was prejudiciary, that the evidence didn't have anything to do with the criminal case, and that you couldn't even prove it. It was just mere allegations, and you muddied the jury. You know what I'm saying? You put stuff out there that really prejudiced the jury against our client. Y'all see that? I'm telling you. Diddy's getting his money's worth right now. Okay, so let's keep listening. Now listen to the rest of it. That's not the end. Now listen to this. So the witnesses should not have even been allowed because it was unnecessary to establish defendant's intent and served only to establish defendant's propensity to commit the crimes charged, using the same exact wording. Weinstein, age 72, was convicted in 2020 of first-degree criminal sexual acts and third-degree rape, and he was sentenced to 23 years in prison. He has maintained his innocence and denied any non-consensual sexual activity, just like Diddy. The Manhattan District Attorney's Office said it plans to retry the case. They say we will do everything in our power to retry the case and remain steadfast in our commitment to survivors of assault. Weinstein has been transferred from the Mohawk Correctional Facility in Rome. Okay, at the end of the day. Now, watch this. I'm going to pull up this video where they talk about Weinstein's case. I'm going to share my screen. Likes up, everyone, please. Like and share. Thank you in advance.
Hollywood film producer Harvey Weinstein has had one of his convictions for rape overturned by New York's highest court on the basis that he did not receive a fair trial. It's ordered a new hearing. Weinstein will remain in prison for a separate conviction for rape. Emma Vardy begins our coverage.
When one of the most powerful men in Hollywood was charged with rape, it led to an outpouring over a culture of sexual assault and misogyny experienced by women around the world. A number of actresses came forward accusing Harvey Weinstein of forcing them into sex, saying they'd been afraid to speak out because of his ability to make or break careers. But now the rape conviction against Harvey Weinstein that sparked the so-called Me Too movement has been overturned in a shock outcome in New York. The Court of Appeals said prosecutors had called witnesses whose accusations were not part of the charges against him. That meant, it said, he was unfairly tried for past behaviour.
Okay, you all heard that, right? One's in the chat if you all heard that. I need to make sure you all are paying attention. Did you all hear that? Did y'all hear what she said? That they had witnesses who testified. Okay, did y'all hear that? Y'all heard it, okay? Oh, thank you, DJ Big Six, beloved. No, it's okay, because it's a news report, okay? It's a news report. So news reports are public domain. Okay, so you don't have to edit those, or I don't have to use an overlay in this case. But thanks, beloved. Good looking out. Okay, and this is fair use. All right, so you all heard that. Same thing I just told y'all about Diddy. Let's keep listening.
Harvey Weinstein was also convicted of rape in a separate case here in LA. Last year, he was sentenced to 16 years for raping a woman in a Beverly Hills hotel. He will remain in prison while a decision is made in New York over whether to retry him. Harvey Weinstein's lawyer has commended the appeals court, he said, for upholding the principles that a criminal defendant should have in a trial. Harvey Weinstein's accusers have called the decision a major step back in holding those accountable for acts of sexual violence. Emma Vardy, BBC News, Los Angeles.
Well, in the past half hour, Weinstein's lawyer has been speaking outside the court. Arthur Aidala said that he knew his client had not received a fair trial.
In this courthouse behind us at that trial, the law was not applied fairly to Harvey Weinstein. And what the Court of Appeals, the highest court in the greatest state, in the greatest country, said today is that, yes, no one is above the law, but no one is below the law either. And the case in which it relies upon is called the Molyneux case. It's over 100 years old. And what the Court of Appeals said, you can't throw out 100 years of legal precedent because someone is unpopular.
Y'all heard that? Now, if you remember, when I was reading those documents, that's exactly the case they brought up, the Molyneux case. Okay, that case set precedence. Now, you cannot throw out 100 years of precedence is what he's saying. That's how he got Harvey Weinstein that appeal. Now, in Harvey's case, they chose to retry his case. Okay, the court deemed that he needed to be retried. The prosecution said they're going to retry him. Now, sometimes they'll retry you if you win on appeal and your case gets overturned. They'll retry you, but sometimes they'll just reverse the decision. Okay? So that's what Diddy's hoping for, if he gets convicted.
Well, more than 75 women accused Weinstein of varying degrees of sexual misconduct going back decades. Allegations he denies. Actress Ashley Judd was among the first to speak up. This is what she had to say in the wake of today's outcome.
First and foremost, I want to say that I stand in sisterhood and solidarity with all survivors of male sexual violence. And today is a day, like every day in American women's lives, when male sexual violence has intruded and disrupted our lives. There I am planning to get my backcountry camping site reservations in Yellowstone National Park, for which I'm very excited. And I get the news from Jodi Kantor of the New York Times that 4 judges at New York's court have voted to overturn Harvey Weinstein's sexual crimes conviction. This is what it's like to be a woman in America, living with male entitlement to our bodies.
So why exactly was this case overturned? I spoke with the former assistant U.S. attorney and professor of criminal law at Fordham University, Cheryl Barder.
So it was overturned on 2 bases. So one is that there were these evidentiary rulings that the court made that allowed in testimony from other victims in incidents that were not actually charged in this case.
Now, y'all hear that, right? They allowed in testimony from victims in incidents that were not charged in the case. Please pay attention. Those were people who made allegations against Harvey Weinstein, but the allegations they made had nothing to do with the criminal case because they were not in the indictment. Do y'all see where this is going? I'm telling you, they're setting it up. So even if Diddy is convicted, they're still going to try to work as hard as they can to get him off, and they're preparing the groundwork, laying the foundation to do so right now, even as we speak. Mark Agnifilo, Tina Garagos, Alexandra Shapiro, and Gustavo Estevallo, they're working overtime. Okay, please pay attention.
And typically allowing in what we call propensity evidence is not allowed. In other words, we don't want jurors to say to themselves, well, he did it before, he'll do it again, or that he has bad character and therefore he's guilty, because that's not evidence of guilt that someone has bad character, has done bad things in the past. There are certain exceptions to that, and the prosecutor had argued here that they should be allowed to have in this testimony in order to rebut an argument that these were sexual favors that women were giving as part of the sort of casting couch culture And so the judge did allow this testimony in, but the appeals court said that that was in error.
That was a former US attorney, Cheryl Barder, speaking to me a little earlier.
Okay. Y'all heard that? Said the judge was in error to allow that in, honey. Diddy's hoping the same thing happens to him if they let that evidence in. If they don't exclude it and he gets convicted, that's the same playbook they're going to go by right there. They're already getting it. They're already putting it together. They're already putting it together, honey. They are throwing everything in. Okay? I want y'all to pay attention. Honey, this trial is going to be juicy. Do you hear me? I'm going to be glued. And y'all already know we're going to be covering it on the channel. Okay? 24/7. All right. Songwriter Sonny said, hold on. The best actress he's ever used is that walker. Yeah, Harvey Weinstein came up in court with that walker all slumped over. I'm like, dude, don't come here trying to act like you're just so weak and elderly and all that, honey, knowing you're a whole monster. Sit down somewhere. I never saw him on that walker until he headed the trial. The Inkwell said a precedent has been set. Yes, of course it has. The Molyneux case, that set precedent 100 years ago. Like they said, you can't just throw that out. Those are the rules. And that's why even though Harvey Weinstein's defense team made the same exact argument, using the same exact words, okay, propensity evidence, okay, prior bad acts, the same exact legalese and language. At the end of the day, the judge went ahead and allowed it to be in. They entered into evidence, allowed those people to testify, didn't exclude it. And you see what happened? Got overturned. Okay, now in his case, like I said, he has a retrial coming up. Let me see when it starts. I do believe that his retrial is scheduled to start on April the 15th. But at the end of the day, it could have also, they can also, rather than giving, asking for them to be retried, they can actually reverse the conviction and then the person just gets off. Okay. Harvey Weinstein's retrial is scheduled for April. Hold on. The trial was delayed until at least next year. This is an old post. Hold on. Yeah, it says that it's supposed to start in March or April. So clearly this month is starting. Okay, it's starting sometime this month. All right. Susan Butler said limping and got to be held up. Yeah, that was all an act. Okay, that man, let me tell you something. Harvey Weinstein is so nefarious. I'll never forget during his trial, I was reading an article about this journalist who said that Harvey Weinstein had someone come and threaten him because he was an investigative journalist. And so he had reported on Harvey Weinstein and somebody came and threatened him. And he said he had to move out of his apartment, had to buy a gun for safety and all this. And let's not forget, Dr. Barbara Ziv, who was the expert witness in Harvey's case against him, she was the psychologist who explained to the court why the accusers would have waited so long to come out and say something against him. And she left court one day and was plowed down. Someone ran her over. Now, fortunately, she lived. But somebody tried to take her up out of there. Y'all don't think Harvey had something to do with it? Because it was a known fact, as they say. It was allegedly a known fact or an open secret of what he was doing for at least 3 decades. And also, they said he was known as a Hollywood bully. Okay? Because he had money and power, could get things done. All right? So at the end of the day, what I'm saying is, his accusers said many of the same things about him that Diddy's accusers have said about him, that they didn't come forward out of fear. He had the power to blackball them from the industry. Okay, same things they say about Diddy holding their careers over their head. It's the same thing, basically. And the interesting thing is, like I said, honey, they're using that same playbook to try to make sure if Diddy does get convicted, oh, we're going to see if we can get this conviction overturned. Okay, get the decision reversed on appeal. Please pay attention. Queen, let's not forget Diddy is a black man. He isn't going to get the same treatment as a white man. Well, here's the thing. We can't say that. We can't say that for sure because, for one, Diddy has those tapes. Okay, Diddy has those tapes for one. And for two, at the end of the day, look at OJ. Look at OJ. It just depends, honey, on the jury. It depends on the jury. That's for number one, but it also depends on the rules. Because here's the thing y'all need to pay attention to. What do you think will happen if Diddy does get convicted and then loses his appeal? All they're going to do is they're going to compare it to Harvey Weinstein's case, and they're going to have the argument now. They're going to say that they did this to Diddy because Diddy's black. Because if Weinstein was able to get if he was able to win on appeal with the same exact circumstances, okay, that they just talked about for Diddy, they're going to make the race argument a thing. Okay? That's how that's going to go. And either way, I don't know whether he would win the appeal or not. The bottom line is, my whole point is he's following Harvey Weinstein's playbook. Okay? And it's not about black or white. In some cases, sometimes it's more so about the money that the person has and what the person has on other people too. Please pay attention. Okay, this is all nefarious. That's right. Nessie X said he still got those tapes. That's what we got to remember. Where are those tapes? Prosecution doesn't have them. The only tapes they supposedly have are the 9 tapes that Cassie gave them. The 9 tapes that Cassie gave them. Who has the other tapes? Where are those? I'm sure they still want to know. And Diddy's not playing ball. He never played ball with them, in my opinion. That's why they never granted him bail. Okay. I saw somebody did a video yesterday saying something about Diddy about to get bail. And I'm like, why would he be about to get bail? The trial's right around the corner. Who needs bail at this point? Okay. Queen, so as you say, let's not forget that Diddy's a black man. Yes, we absolutely know. Okay. But the bottom line is he's setting the stage. They are following the same pattern. So we'll see how it all turns out. All right. Hopefully Diddy gets whatever he deserves. All right. We don't know if Diddy's guilty or innocent, but I think he's guilty. So at the end of the day, I'm just going to pray to the Most High that Diddy gets whatever he deserves. All right. That's all we can do. DJ Big Six said Diddy holds the cards. Exactly. So Adrian Marie, beloved, thank you for your insight into the topic and your contribution to the channel. Peace, love, and blessings. Jeff ATL said, let Diddy stay in there until he dies. Y'all are so nefarious. Okay, with that all being said, I'm out of here. Okay. Poetical Wind says evil spirits use the same tactics all the way up to the executive office. Yeah, absolutely. Okay, so anyway, with that all been said, listen, I love you all to life. Okay, I'm about to post a couple of uploads, so be sure to check those out. If you missed the broadcast from yesterday, check those out at your leisure or whatever. And you know, if you don't get notifications from the channel, y'all know I go live every morning. So just check the channel. Okay, just check the channel, and you may miss the live, but you can catch it on the replay. And shout out to the replay gang. All right, so I'll be on the spiritual channel later, and I may come back on here later on today, maybe around 6, I'm thinking, to talk about Trump and some more stuff that's going on, okay, with politics. All right, so anyway, I love you all to life. Each one teach one. That's how we grow and thrive. Do something productive, constructive, but never destructive. And always remember, beloveds, to keep the Most High first in your lives. Until next time, peace.
Hey, yo, Nick, hit him with that gold all in my skin, God all in my blood, kings all in my circle. You touch one of mine and you're done. They show no love for the queen. Why you hating on me? Is it cause I'm free and I got Malcolm X in my jeans? I got dreams like King Luther, shed blood like Kunta. You ain't helping my people, I ain't got nothing to say to ya. I want all the smoke like hookah. Talking reparations, America won't be great until they give us compensation. I'm like, I'm the hottest right now. See a bunch of lames out here trying to jock on my style. They be doing too much. I'm the queen, it's too easy. It's like they all at Popeyes, how they be talking so greasy. I just sit back and laugh while these haters get madder. So nefarious how they don't want my pockets with cheddar. I tell them they can do better. These snakes in the grass can leave a bite on your ass, cause y'all be trusting too fast. I got my foot on the gas, other one on they necks. Dropping receipts on haters, you better show some respect. I'm never facing regrets, we only facing the threats. Running through every challenge like a relay, break no sweat. It's a cold game, so I got that blanket with me. Now that my people awaken, ain't no going to sleep. I I do not play by my piece. This time I'm playing for keeps. You talking slick, but when I see you like them ends, we gon' meet. And I got gold all in my skin, God all in my blood, kings all in my circle. You touch one of mine and you done. They show no love for the queen. Why they hating on me? Is it cause I'm free and I got Malcolm X in my jeans and I got gold all in my skin, God all in my blood, kings all in my circle. You touch one of mine and you done. They show no love for the queen. Why they hating on me?